Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible William Porter, a California construction lien law guru. Today's webinar topic is what happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the fabulous William Porter.
Well, thanks so much, Jesse. Such a nice introduction. I'm not sure I deserve it. I'm just a hardworking, bloke like everybody else listening to this. But let's just get right into this. We got like 20 minutes, and we're going to roll through this. If anybody has any questions, just there's a method on the system to raise them. Or if anybody wanted to give me a call, and my number's right there on the screen, and say they were at the seminar and they had a question, that's fine too. Okay. Anyway. Here are how to raise questions, which will be at the end. And don't include your company names in the questions, please. And there's a little legal disclaimer basically saying, I'm giving general advice, and there are exceptions to all of this. It's a complex topic, and those are the kinds of things that arise often during litigation. They're just, you never know what a judge is going to do on these things. But we're going to go over general rules that are fairly well established anyway. Okay. This is a little bit about me. I've been around a while. I wrote some of the laws that we're going to be discussing today, or I updated them way back in 2010. I'm very much involved in the construction industry, and I teach many things in the industry. Besides, like I am today at work, just doing legal work. Okay, let's talk about the mechanics lien lawsuit deadline. Now, at this point, because we're picking it up at the point where you already have recorded a mechanics lien, and then it's kind of like, okay, well, what do I do now? And you may have not only a mechanics lien, you might have a stop payment notice, and you might have a payment bond claim. And these are all things that you probably did, or you used a service like SunRay to do, and you're ready to roll. But now you got to get to the legal part of things. And so there's timing aspects that you have to understand. The first of those relates to the mechanics lien lawsuit deadline. So under a California law, once you record a mechanics lien, you are going to have 90 days to file a lawsuit. If you don't meet that deadline, then your mechanics lien will expire. It'll still be on the title to the property, and we'll discuss that in a minute, but you can't miss this 90-day deadline. Now, there are ways to extend it. One of those is called a notice of credit, and we'll talk about that in a moment. It could extend the lawsuit to file the lawsuit deadline for up to a year from when all the work was last finished. Okay, so that could give you a large amount of time to work things out. But honestly, I'm not a big fan of using the notice of credit because people just try to figure out other ways to avoid paying you. All right, also on the 90-day deadline to file a foreclosure lawsuit, which will just be part of a bigger lawsuit where you'll have breach of contract and other claims, don't go to your attorney like someone did the other day, 2 days before the 90th day deadline, because it's too short of a period of time for an attorney to run a conflicts check and do a number of other things and get a lawsuit on file. So really, you want to start talking to your attorney 2 or 3 weeks before the deadline will expire. And in the meantime, try to get paid so that you don't even have to use an attorney. And once you get paid, you can release the mechanics lien. Okay. So let me note that if you inflate your mechanics lien, let's say you're owed $100,000, but you put 125 for some reason, maybe some specious reason, maybe because you thought that you might have to negotiate it and you would end up at 100,000 even though you claimed 125. But anyway, the penalty for a false or inflated mechanics lien, if the other side can prove it, is that you lose your entire lien. It doesn't get adjusted down to the correct sum. You just lose it. Okay, so that is a scary thing. Also, I should note that if you do file a foreclosure lawsuit on the mechanics lien using an attorney, then within 20 days after you file it, and it's something to raise with your attorney, the attorney needs to record a notice of pendency of action. That's something that gets recorded to let everybody who might look at the public record know that the 90 days may have passed, but you didn't missed the deadline, you actually filed a lawsuit. So it's telling everyone, hey, I have a lawsuit now. I had a lien. Now I also have a lawsuit on the lien. So it's going forward. It lets them know. Otherwise, you know, somebody could sell the property out from under you, even though you have a lien. And then technically someone could argue, hey, they didn't send a notice of pendency of action, so I thought the lien was expired. And then the judge might say, yeah, I'm going to release the lien because they should have filed a notice of pendency. So those are two things that you need to be aware of that are important in enforcing your mechanics lien. Now here, I talked about this notice of credit. Okay, so let's say the owner of the property comes to you and says, hey, I'm going to get a chunk of dough in about 3 weeks, but that's going to be beyond the 90-day deadline. So can you not file the lawsuit within 90, you know, until after this time? And then you would have to say, well, there's a 90-day deadline. If I don't file within 90 days, my lien is no good. It expires. And then it's possible that you could get the owner to sign a document called a notice of credit, and it's probably something that SunRay can do, and it could extend the deadline for filing your lawsuit for up to a year after the work was performed. But shoot, when I have done this, sometimes it has worked, but a lot of times the financial problems of the owner get more and more detrimental, and then maybe they'll file bankruptcy, you know, and so you just got to watch it. Once someone files bankruptcy, it just gums up everything. Although I will say this, that if you have filed a foreclosure action and the owner files bankruptcy after that, then you're a secured creditor, and you would get paid first, and you would get paid in full before any of the other creditors would get anything. And so it's valuable in a bankruptcy to have a mechanics lien and a mechanics lien foreclosure action. Okay. All right. So what if you get paid? Then you do have to release the mechanics lien, and there are different ways that you can do this. So you could just have the form, and SunRay can do it. It's just a release of mechanics lien form. It gets signed before a notary, and then it gets recorded, and that releases the lien. That's great. If you don't release the lien, though, there's a problem that could happen. So let's say that you don't get paid, and the 90 days has expired. So you have a lien on there. Nobody knows if you filed a lawsuit on it or not. And so a rule has developed, which is supported by the statutes, that you have to release the lien even though it's expired. And what will happen is that the owner will come to you, probably a certified letter, maybe from their attorney, and it'll say, hey, please release that mechanics lien because it's expired. So if you don't release the lien, then what can happen is that they will go to court and a judge will release the lien. But the bad thing for you on that is that the judge will impose a judgment against you, which will be calculated as all the attorney fees and costs that the attorney had to spend to do a motion to the court and get the lien released. And I have found that those are usually like $4,500 to $5,000, and that's a judgment against you. And it's enforceable like any judgment. But also, if you're licensed and someone has a construction-related judgment against you, they could send that to the Contractor State License Board, and the License Board will suspend your license to perform work under your license until you pay on that judgment. So it's important to release your lien if you haven't gotten paid, and either you have to file a lawsuit on the lien or you have to release it. Okay. All right. Oh, and I mentioned this here at the top part of this page, that a judgment could be sent to the CSLB, and they'll suspend your license. And note in the second part of this top paragraph that if you do any work in California when your license is suspended because of a judgment or something like that, then you could be subject to disgorgement, which means that any money at all that you got paid on a project from the beginning to end, when your license was suspended for part of that project, you may have to give all that money back to whoever paid you. So if you want to learn more about this, there's a couple articles on our website about it, but you could also just probably Google California contractor disgorgement, and you can learn more about it from other people's articles. Also, I might note that a really cool thing about mechanics liens is that the effect of the mechanics lien relates back to when someone on the same project first performed work on the project. So this is helpful when someone gets, let's say, a construction loan or some type of loan on the property. And then later on, you didn't get paid and you recorded your mechanics lien. Well, the priority of your mechanics lien on getting paid doesn't start at the point where you record the lien. The priority goes all the way back to when somebody, not even necessarily you, but somebody on the same project, some other contractor or subcontractor, performed work. Then all the mechanics liens on that project relate backwards in time, and you should be able to get paid first. Let's say there's a bankruptcy, like we discussed before, but you would get paid first before anybody who recorded a deed of trust or anything like that after you. So the relation back effect of mechanics liens is really important and often quite helpful. So I thought I'd mention it. Okay, now that's the thing on mechanics lien. Mainly, it's you got to file your lawsuit within 90 days, and don't go to your attorney on the 89th day, right? Have a few weeks. Same thing with the other remedies, but one of your other remedies is a stop payment notice. And although it's beyond the scope of this, the stop payment notice is something that says to the owner or the lenders, hey, I am owed money. Stop paying out and hold my money for me. And they'll hold your money for you probably plus an additional 25%. Okay, now there's a lawsuit deadline for this too. And it's going to be 10 days from the date the stop payment notice. Well, the earliest you can do a lawsuit is 10 days after you serve the stop payment notice. You got to wait 10 days. Although some judges say, they don't care about the 10 days, but that's another story. But your outside deadline is no later than 90 days following the expiration of the period within which stop notices must be served. Ooh, that's kind of complicated because you have to figure out the last day and then add 90 days. But here's another way to calculate it, because that's the way the statute reads. But typically a stop payment notice is going to be determined from completion of the project, or a notice of completion, or notice of cessation. Okay, you can use that to make your calculation. What you would do is that the deadline to file a lawsuit on the stop payment notice claim will be either 180 days from the day the project was completed, or if there's a notice of completion or a notice of cessation and it's a valid one, then it's going to be 120 days from the date of a valid notice of completion or notice of cessation, whichever's earlier. So let's think of this in context of the mechanics lien. The mechanics lien is merely 90 days after you record your lien, whereas the lawsuit deadline, whereas the stop payment notice lawsuit deadline could be a longer period of time. Let's say 120 days from a valid notice of completion, or if there is none, then 180 days from the actual completion of the project. So I would say that probably the best thing to do, given the two deadlines, is once you record a lien or once you send a stop payment notice, I would calendar 90 days later to file your lawsuit, because then you'll never miss a deadline, because the lien deadline for filing a lawsuit on the lien is the shortest one. It's 90 days. The one on the stop payment notice could be 180, 120. It's longer. So just do 90. 90 is plenty of time to wait to get paid after you've recorded a mechanics lien or stop payment notice, because by that time it's probably already delayed quite a bit of time. So I would just use 90 days. But here's the technical deadline for the stop payment notice lawsuit. Okay, and then just like the mechanics lien, be sure to talk to your attorney a few weeks before the deadline and release your stop payment notice if you get paid. Okay, for the same type of reasons, you could get in trouble with the public entity if it's expired and you don't release it. You do have to release it. Okay, the third remedy, we did the mechanics lien, we did the stop payment notice. You may have a payment bond lawsuit deadline, or you may have issued a payment bond claim, and now you have to have a lawsuit on it. So again, go to your attorney a few weeks before, but the payment bond deadline for a lawsuit is within 6 months after the work of improvement is completed. Okay, and all the code sections are here, and you can look up these code sections, which have been throughout, like the Civil Code 8609 here and the Code of Civil Procedure 337. At the end of all these paragraphs, there are code sections, and they're really easy to look up. You could just say California codes, and then a whole bunch of codes will pop up. You click on Civil Code, and then you can go to 8460. You can read the details of that law. But at any rate, this one is way out there, 6 months after the completion of the work of improvement. I would go with the 90 days, which is half that, and then you'll never miss your deadline. Oh gosh, I'm done. I'm done quicker than I thought that I would be done. Are there any questions, Jesse?
Yes, there are a couple of questions that came through. So the first one, it says, can I amend my lien if it's still within the deadline to adjust the amount?
That's a really great question. Here's the answer to that. You could amend your lien downward by doing a partial release of mechanics lien, which is something that you would sign before a notary, and then you would record that at the county recorder. But you can't amend your lien upwards in amount. Now, here's another thing that you could do. If you are within the time period for recording liens, which was part of the premise of your question, if you're within that time period, what you could do is you could simply release your existing lien, and even on the same day, record a brand new lien, because you're within the time period for recording liens. It just becomes kind of a substitute, but it's just a different lien, and the other one is dead because you've released it. Also, I should mention regarding releases of liens is that if you have a multi, let's say you work on a neighborhood where they built 20 homes and you did the work, but haven't been paid, you could do a partial release of mechanics lien using that document, and you could release the lien lot by lot by lot by lot as you get paid. So there's two ways to go on those. You could either release your lien or reduce your lien amount by the amount that you get paid, or you could release individual lots so that they can be sold. But anyway, there's some info on that. Another question?
Wonderful. Yep, another question that came through. It says, in California, is there any kind of a lease provision that would limit my ability to lien the real property if I was hired by the tenant to do the work? And if so, does that need to be recorded in the county before the work was done? And can I put a lien against the tenant's interests?
Yes, I think the whoever asked the question has good instincts and probably knows the answer, but some people may dispute it. And there is an issue of dispute on this. I have written an article on it. It is on our website at porterlaw.com. But an owner of a property can, if they wish to, perhaps effectively and perhaps not, they could record or post a notice of non-responsibility. And what the owner is trying to do by doing this is it is used in a situation properly when an owner comes upon construction work being performed on their property and they go, well, whoa, what is this? And then they post a notice of non-responsibility. Now, I think that almost always such a notice is improperly used. And that is because of a provision in a contract, which is a provision in a lease contract. Now, typically in a lease, the tenant will come in and say, oh, I am going to perform improvements, and the owner already knows that the person is going to perform improvements. And then based on that, it is not fair for the owner then to disavow what's in their lease and try to post a notice of non-responsibility, meaning like, oh, you should not be able to put a lien on my property because this was all a surprise to me. So yeah, there is a provision that is put in a lease, but generally it has the opposite effect. And what it is a statement by the owner that they know that improvements are going to be performed, so this should not be a surprise to them. So I would say that I would go ahead and record a lien, even if there's a notice of non-responsibility, because then later on in the legal world, we do what we call discovery. And we will do a subpoena to the owner and to the tenant, and we will say, please provide us a copy of your lease and correspondence and all this stuff, and then you'll be able to prove, hey, the owner knew that this improvement was going to be done, therefore the notice of non-responsibility is not valid, and therefore my lien is valid, and somebody better pay me before I sell this property. And there was another part of the question.
If there is a lien lease provision, can you put a lien against the tenant's interest?
Yes, yes. Yes, you can. I have done that a number of times because a leasehold interest is like a temporary, for a duration of time, ownership of the property. So yes, I have done foreclosures on leasehold interests, but of course then once you get it, what do you do with it? The effect though of it is that you're really disrupting someone's situation, and typically what happens is that somebody decides, I better pay on this debt, otherwise I'm going to have a real problem, and usually either the owner or the tenant or somebody will pay. It honestly is very rare to actually go forward all the way with the sale of a piece of property on a mechanics lien. It's really rare, and I would say that in 30 plus years of doing this, I've only had a handful of times where I have ever done that, and at any given time we probably have 20 different lawsuits on mechanics liens going on, and it's just rare as can be.
Okay. All right. Well, thank you. Bill, would you mind going to the next slide for me, please?
Yeah.
Okay. And then we have another question that came through. It says, does the notice of pendency get recorded or served, or is it just mailed to the parties within the lien?
No, it gets served too. It gets recorded and served. But if you look at the document, I don't have one in front of me at the moment, and you look at the statute, it'll instruct you of who to serve, and probably it would be the owner. It probably would be anybody who is named in the lawsuit, because you're going to have the owner there, you're going to have the contractor there, you may have a subcontractor there, you may have a bank there, and so probably I would serve everybody, but you have to do it in a certain way. Once you get to that point, once it's a notice of pendency, then you're dealing with attorneys, and the attorney will have a process where they do a proof of service, and that's generally at that point something that the attorney's office will take care of, hopefully.
Wonderful. Thank you.
Point out to them it needs to be done.
Okay, wonderful. Thank you. And then I do believe that this is the last question that's come through. It says, if a private commercial project has a bond on it, can you do both, file a lien and file the bond claim?
Yes, indeed, and the stop payment notice. So here's what could happen is that, let's say you did a mechanics lien, you recorded a mechanics lien, you sent a stop payment notice, and you sent a claim to the bond company. What if you didn't do something right on the mechanics lien? What if you were late, like you were on 91 days, and then as it turned out, you would not have a valid mechanics lien claim, but that doesn't mean that you don't have a valid stop payment notice or payment bond claim. So what happened, and of course you have a breach of contract claim too, and there are other things that you may have in your lawsuit depending on the facts, but what happens at the end is that a court will figure out which is the method by which you will be paid. Is it going to be the bond company? Is it going to be stop payment notice? I would think that probably first you would get the money from the stop payment notice, and then if something was left unpaid, you might get it from the bond company. But probably what would happen is that one way or another, the main party that owes you the money is going to pop up with the money, because, for example, on a payment bond claim, the general contractor generally is going to be obliged to defend and indemnify the bond company. So the bond company is not going to just pay and sit there. They're going to start knocking on the door of the general contractor, who's going to have to reimburse them. So, and the general contractor will be knocking on the door of the sub. So eventually, whoever owes you the money probably is going to pay you, but let's say they go bankrupt, then it's going to fall to the stop payment notice and or the payment bond company. So typically it doesn't get there, but yeah, you can do all three: mechanics lien, stop notice, bond claim, plus breach of contract, plus prompt payment remedies, whatever it may be, all in one lawsuit. And if one of them fails, that doesn't make the other ones fail, and you can get the money there.
All right, wonderful. Thank you so much. I do believe that, like I said, that was the last question that came through. If you do have a question that wasn't addressed, please feel free to reach out, and we'll be sure to answer any questions for you. Bill, you are incredible, so thank you so much for that. Can you go to the next slide for us, please?
Surely. There you go.
All right, here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Next slide, if you don't mind, please. All right, our next webinars with Bill are going to be Thursday, August 14th. That's statutory construction releases. And then on November 13th, getting paid faster with liens, bonds, and contracts. So please sign up for free at sunraynotice.com/education. We'd love to be able to see you there. And then the next slide, if you don't mind, please. All right, so if you can give us a review through Google, we really do appreciate the feedback that you're able to provide. It helps us better our content and make sure that we have the webinars with the information that you're looking for on there, as well as just bettering our services. So if you don't mind, give us that feedback.
And if anybody listening has any questions that they didn't get answered and they wanted to give me a call, my number was on the very first slide, and I would be happy to take your call anytime in the next couple of weeks.
Perfect. And then Bill, if you can go to the last slide for us, please. It will have your phone number on there again for them. All right, and with that, that is all we have for you guys today. Thank you so much to everybody who attended. We hope to see you at our next webinar. Again, Bill, you really are incredible, so thank you so much for your time. I hope you all have a beautiful and wonderful sunny day. Thanks, everyone.